It is undeniable the importance of creative ideas and innovative technology in today's global economy. The Korean Intellectual Property Office, also known as KIPO, is the governmental agency of the Republic of Korea responsible for the administration and processing of patents, utility models, trademarks, industrial designs, and trade secrets. Working at the forefront of the Fourth Industrial Revolution, KIPO strives to realize innovation through supporting the adequate utilization of intellectual property. KIPO is affiliated with the Intellectual Property Trial and Appeal Board, which conducts trials on IP disputes, and the International Intellectual Property Training Institute, which provides training for IP experts and users. KIPO currently employs around 1,778 staff, including 857 patent examiners and 172 trademark and design examiners. Of these, 490 hold PhDs, 414 are patent attorneys, 29 are professional engineers, and 19 are attorneys at law. The number of IP applications filed in Korea continuously increased to the extent that Korea is the world's fourth largest creator of patents. Also, Korea ranked 5th in the 2021 Global Innovation Index revealed by the World Intellectual Property Organization, which evaluates the innovative capabilities of 132 countries. KIPO has actively participated in international cooperative efforts in order to reduce examination workload and effectively enhance the global IP system. We closely collaborate with the IP offices of the United States, China, Europe, and Japan within the IP5. And through this successful framework, the TM5 and ID5 were created to improve examination efficiency and quality. To reduce the time and costs required to patent inventions internationally, we are implementing the Patent Prosecution Highway with a total of 36 countries and regions. In addition, examination cooperation has been gradually strengthening through the collaborative search programs, starting with the US in 2015, with China in 2019, and with Saudi Arabia in 2021. KIPO provides prompt examination services. The average pendency of first office action at KIPO is about 11 months for patent and utility model applications, about 9 months for trademark applications, and about 5 months for design applications. KIPO boasts the advantages of world-class speediness. In order to provide high-quality examination services, KIPO carries out activities to strengthen examination quality control. KIPO provides 3 tracks of patent and utility model examination and 2 tracks of trademark and design examination so that customers can select an appropriate examination track according to their own IP strategy. The examination process at KIPO generally means going through the procedures of filing for an application: formality examination, request for examination, substantive examination, decision of grant, and registration. Applicants can file patent applications in Korean or English. KIPO has shortened the request for examination period from 5 years to 3 years in order for an earlier confirmation of rights. During the substantive examination stage, an examiner will ask an applicant to submit a written opinion and amendment if there are reasons for rejection. At this time, if the reason for rejection is resolved through the written opinion or amendment, the examiner will make a decision of grant, if not, a decision of rejection. If an applicant is not satisfied with the result of the examination, the applicant may file a request for an appeal against the examiner's decision to reject the application. Subsequently, the Intellectual Property Trial and Appeal Board's decision can be appealed to the Patent Court, an IP-specialized high court, and an appeal against the Patent Court's decision can be made to the Supreme Court. A petition for IPR infringement can be filed before the District Court and then appealed to the Patent Court. Recently, in patent, trademark, and design examination, to actively resolve oversight by individuals and SMEs with weak IPR foundations, and to ensure the best opportunities for obtaining rights, KIPO has extended the time limit from 30 days to 3 months, to request litigation against a decision of rejection and ease the condition from reasons beyond one's control to justifiable reasons, to restore expired rights caused by missing documents or non-payment of dues. KIPO has also introduced the ex officio re-examination to prevent defective IPRs from being registered. In patent examination, implemented were the automatic acceptance of priority right claim for divisional applications and the filing of domestic priority claim applications after granting of patent right, etc. KIPO has introduced remedial measures to the grace period. Applicants can apply for a grace period before the official establishment of right or for a grace period at the point of filing. With regard to trademarks, not only traditional marks composed of symbols, letters, colors, etc., but also non-traditional ones, such as sounds and scents, can be registered and protected as trademarks. The timing to determine validity of the reason for refusal of trademark registration has changed from the time of filing to the time of decision on registration. With respect to designs, definitions of certain terms were newly established to include computer-generated graphic designs, and the stipulated actions considered as the working of a design was supplemented for online and offline to provide a basis for protecting these new forms of designs. In addition, to prevent the imitation of only the characteristic parts of a design of the set of articles, the partial design protection system had been introduced for a design of a set of articles. Furthermore, KIPO has allowed the submission of font files for typeface design and expanded the drawing formats for submission, thereby alleviating inconvenience for applicants. Meanwhile, items subject to the partial substantive examination system have been expanded from 3 to 7 classes, such as food, personal items, decorative items, etc., enabling early acquisition of design rights for short life cycle products. The Intellectual Property Trial and Appeal Board, IPTAB in short, is a quasi-judicial body set within the KIPO in order to conduct special administrative trials and appeals for IP dispute resolution. One of the major cases highly requested is an appeal against an examiner's decision of rejection. The appeal proceedings start with a formality examination, followed by the designation of a panel of administrative judges and examination on merit. If an appeal is affirmed, it shall be remanded to the examiner, and if rejected, it can be appealed to the patent court. In addition, the IPTAB conducts various trials, including a trial for correction, which allows the correction of patents and utility models after they are registered, a trial for invalidation, where an interested party may seek to invalidate the granted IP rights retroactively or prospectively, and a trial to confirm the scope of IP right, which allows patent right holders, exclusive licensee, or interested parties to verify the scope of protection of a patented invention. A 3-track trial system is offered in order to more efficiently handle trials that require expedited decisions based on the user's needs. To prevent defective patents, the IPTAB implemented patent opposition, in which anyone can request to cancel registration on the grounds that there is a lack of novelty or inventive step within 6 months from the date of the publication of registration in the Patent Gazette. Furthermore, the IPTAB offers a full refund of the trial request fee to the applicant if the examiner's decision of rejection is revoked without fault of the applicant. Meanwhile, the IPTAB works with technical experts, where the presiding judge can hear opinions from private technical experts if necessary to supplement the technical expertise of administrative patent judges in high-tech fields such as artificial intelligence and autonomous driving. If it is deemed effective to use the mediation system during the trial proceedings, the presiding judge may refer the case to the mediation committee with the consent of the involved parties, and if mediation is established, the petition for trial is withdrawn. Trials with the IPTAB can also be operated with video hearings, which allow parties to remotely participate in an oral hearing at KIPO's Seoul branch office, without having to physically present at KIPO's Daejeon headquarters. Korea ranked 4th for the number of PCT applications and Hague applications. Korean, known as Hangul, became one of the official languages for PCT international publications, joining others like English, French, German, and Spanish. Based on high performance of PCT application, KIPO and 16 countries from around the world signed a PCT International Search and International Preliminary Examination Service Agreement to provide fast and high-quality service. As a result, numerous global companies continuously prefer KIPO as the designated office for PCT International Search Report. KIPO will continue to strengthen its performance of offering high-quality examination and trial services.